Hold on. I guess on that meme, this is actually true. Apparently they filed another meme today, arguing to have like every witness automatically sealed. So again, it's not ordinary or normal that witnesses' identities are protected, even in these cases. I've read an okay amount of case law on this now, because I read their citations and I read my own law firm citations, and you can look up other citations for Doe cases that reference the civil statute. I don't know if anybody in their law firm has read a single case from start to finish on any of this or any of the motions or any of the filings. If they have, they are very good at seeming like they haven't. But because witnesses are just not ordinarily protected in any of these cases. Wait, hold on. There was a... Where is the zip zip? What is that? Which citation are you talking about? Which one? Are we still talking about protected from you, the defendant, from knowing them? Well, that's never the case. But even sealed publicly, witness identities are typically not publicly sealed either. Not by default. Certainly not by default. You can file to make a request, but that's not the default. And you have to make an affirmative argument for why an identity ought to be sealed. The argument that they keep trying to make is that these witnesses have like embarrassing personal information, but they don't have to cite any of that. There's no reason for them to do that. They just continue to do it over and over again because the goal is to just defame me in court filing so that I can't countersue for it, which is one of the most important things I think for Pixie in this case, is to just constantly defame me. She even brought that up in the hearing and that we had, that they cried and moaned to get the transcript sealed on, that they're trying to get the transcript permanently sealed on. She brought up that, like, oh, like, I think he sent this video to an underage girl. She was 17. And it's like, you have no idea. You have no idea what the fuck you're talking about, but okay. Tellingly, none of Bonnell's cited cases involve allegations of sexual misconduct such as cyber harassment. This is, like, plaintiffs offered nothing in the record to show any intentional harassment or anything here, but okay. Page 3 under argument 4. Bonnell's frivolous standing challenge and the right of third-party witnesses to remain anonymous in the cyber harassment action. Despite the foregoing reality, which entirely neutralizes Bonnell's challenges to the proposed protective order, plaintiff addresses Bonnell's remaining arguments, including his inference that plaintiff lacks standing to request that the identity of certain of her witnesses remain confidential. Courts routinely fashion protective orders for purposes of shielding sensitive information about third-party witnesses if so requested by a party to the action. And then they cite this case versus Procter & Gamble, affirming blanket protective order issued to protect, among other things, identity of witnesses to avoid disclosure of highly personal and embarrassing information. So... Procter & Gamble appeals from a discovery protective order granted by the district court under the Federal Rules of Civil Procedure 26C, denying it access to the names and addresses of women who gave the Center for Disease Control personal information as participants in the center's toxic shock syndrome studies. So it sounds like this has to do with accessing names and addresses of women who were participating in like a medical study relating to toxic shock syndrome. I wonder what they cite here to approve that protective order. Oh, they do say in here, though, the court mentions this. The law's basic presumption is that the public is entitled to every person's evidence. That's your starting point, is that when there's a filing in court, the presumptive starting point is that everything is public. That's how our court system works. That's where you start from, and then you have to make affirmative arguments for why something ought to be sealed or protected. However, Federal Rules of Civil Procedure 26C provides that a court, for good cause shown, may make any order which justice requires to protect a party or person from annoyance, embarrassment, oppression, or undue burden or expense. Rule 26C articulates a single standard for ruling on a protective order motion, that of good cause. Federal courts have superimposed a somewhat more demanding balance of interests approach to the rule. P&G's interests relate to its trial preparation and defense. Those are important interests, and great care must be taken to avoid their unnecessary infringement. Social science research studies on their own occasion. Courts have taken notice. We're not here ruling on admissibility. However, it will be the response of the courts in which the state's trial, the record and argument for this court shall the district court act within its discretion in holding that the senator's interest in keeping senators outweigh the. Okay. First, the senator's purpose is the protection of the public's health. Central to this purpose is the ability to conduct probing scientific and social research supported by a population willing to submit to in-depth questioning. Okay, so they did uphold this protective order here, which makes sense. But it's funny that they would cite that case. Courts routinely fashion protective orders for purposes of shielding sensitive information about third-party witnesses, if so requested by a party to the action. See, for example, Fansworth and Procter and Gamble. That's a crazy. If you're ever bored, the citations that plaintiff's law firm, which maybe they all do AI. Maybe it's literally all just shit posting AI, and that's all this firm does. Every underlying citation they use is so funny. Sometimes it's for protective orders that don't do what they say they're for. Sometimes they lose. So it's just ridiculously stupid. So like here, they're saying, affirming blanket protective order is issued, inter alia, which I think means among other things, right? That's what that means, right? Among other things. Identity of witnesses to avoid disclosure of highly personal and embarrassing information. But it sounds like the protective order that this court was granted had more to do with the CDC's purpose is the protection of the public health. Central to this purpose is the ability to conduct probing scientific and social research supported by a population willing to submit to in-depth questioning. Undisputed testimony in the record indicates the disclosure of the names and addresses of these research participants could seriously damage this voluntary reporting. Even without an express guarantee of confidentiality, there is still an expectation, not unjustified, that when highly personal and potentially embarrassing information is given for the sake of medical research, it will remain private. Second, P&G was provided with an enormous quantity of information regarding the center's research into toxic shock syndrome. Every single document requested was delivered. The sole deletion concerned names and addresses. It's not like I don't get it. It's Jane Doe just intending on going out with a bang. Any future legal career must be sustained or stained. This person is not ever going to law school. I think initially they were gaslit or yaslit by a bunch of retards that all hate me, people like Jistical included, that I think have a lot of responsibility in what will be like the destruction of plaintiff's life basically after this. But now this is like her whole life mission is probably to try to destroy mine. Like it's basically the only thing she has going for her. And so this is like her whole thing. They weren't witnesses. They were lying about what this case says. Sure. Third-party witnesses. I guess kind of, because they weren't really witnesses. It was just medical data that, it's not even, I don't know if that would be even considered a witness. Isn't this going to leave her completely broke? My guess is the attorneys, at least one of them I think is a family friend, and I think that they're just doing it pro bono. So she's probably just stealing your money from the Gibson Go. In fact, contrary to Bonnell's contention, courts have recognized that such protection applies especially to third-party witnesses, given that these witnesses have not chosen to avail themselves of the public forum of the court. Fuck, do I want to read all these? I stopped reading a lot of their underlying because it's just boring now. Everything that they cite is just so fucking stupid. I wonder what this has to do with chosen to avail themselves of the public forum of the court. Fuck, it's not cited here, or it's not in this. And many litigants would love pseudonymity. That's particularly obvious for defendants. Hey, that's me. Most of whom are being sued over alleged misconduct. Indeed, defendants can claim a stronger case for pseudonymity on the theory that such a defendant is not the one who has chosen to avail herself of the public forum of the court. Holy shit, wait, hold on. I'm misunderstanding this. This has to be a different citation. This cannot possibly be... that can't possibly be real. Hold on. No shot is this real. I'm misreading this. Give me a second. Hold on. Because this underlying citation is saying that people like me would have a public interest in having a pseudonym, and they're citing this case. A defendant, that's me. Many litigants would love pseudonymity. That's particularly obvious for defendants, most of whom are being sued over alleged misconduct, and then they cite to that case. These guys cite to a case saying that witnesses have not chosen to avail themselves of the public forum of the court. But that's not true, though. The witnesses literally have chosen to avail themselves. They're not being compelled by any subpoena. They're not being compelled by anything. They're not being forced to come forward by some kind of order or arrest warrant or anything else. Before, a typical employment lawsuit, for instance, would rarely be reported in newspapers and Googling people's names will often find many of the cases which they participated, even if no reporter has ever written about these cases. Pseudonymity is thus a question of interest to privacy scholars and not just civil procedure scholars. Note there's a different issue from whether private parties publishing information from court records is restrictable. It isn't. Or whether a European-style right to be forgotten should be adopted. This article focuses only on what information should be... Wait, what is this underlying court case now? Also, wait, hold on. Did they... No, hold on. Chosen to avail themselves of the public forum of the court. Hold on. Wait, no. Why? Chosen to avail themselves of the public forum of the court. Third-party witnesses. This has to do with the defendant? Fuck, hold on. I really want to see this. Is it the exact same... Destiny click link. The court's previous order that Jane Doe may proceed under pseudonym. And Jane Doe is the defendant in this case. In an order on November 16, 2017, the court granted defendants administrative motion to allow Doe to proceed under pseudonym and to seal the filings containing Doe's true name. Because the court issued this order on the evening before the planned evidentiary hearing on plaintiff's second emergency motion for a preliminary injunction, the court did not have time to issue a detailed order. As a result, the court now provides its reasoning for granting the administrative motion. A district court has discretion in deciding whether to permit a party to proceed anonymously. The court must balance the party's need for anonymity with the prejudice to the opposing party and the public's interest in knowing the party's identity. In general, compelling reasons sufficient to outweigh the parties or the public's interest in disclosure and justify sealing court records exist when such court files might have become a vehicle for improper purposes, such as the use of records to gratify private spite, promote public scandal, circulate libelous statements, or release trade secrets. With regard to allegations of sexual assault or sexual harassment in particular, courts in the Ninth Circuit have found that allowing victims to proceed anonymously, victims would be plaintiffs, serves a strong public interest in protecting the identities of sexual assault victims so that other victims will not be deterred from reporting such crimes. See Doe v. Penzato. Okay. Quote, in keeping with the tradition of not revealing names of the victims of sexual assault, we use initials here to protect the privacy of the inmates. In EEOC versus ABM Industries, for example, a court permitted plaintiffs to intervene anonymously, in part because they were concerned that they would be embarrassed by the public disclosure of the nature of their allegations against defendants, which, if proven, will identify them as victims of sexual harassment and sexual crimes in the small community where they live and work. Defendants argued that Doe's need for anonymity outweighed any potential prejudice to plaintiff and the public's interest in knowing her identity. Defendants alleged that plaintiff brought this lawsuit for the purpose of embarrassing and intimidating Doe. At one, defendants argued that plaintiff included in the complaint private information about Doe's performance in his course, as well as the sensitive allegations that she privately made in a confidential university investigation. So like all of the random stupid shit that Pixie included in her complaint that was totally irrelevant, a lot of which they've admitted, by the way, is utter bullshit. I don't know if that's private or if that was part of the hearing, but in the hearing they admitted that like half the people had deleted their accounts, that they had I don't know if I said this or not, one of the very specific lines of questioning, by the way, was, have you seen evidence relating to Abby MC, the mystery prisoner? Have you seen evidence that Stephen Bunnell transmitted any video to her at all? Or is it just her saying it to a friend? And after some back and forth, she answered, no, I've never seen any evidence. And the question was, have you seen any evidence of him transmitting this video to anybody at all beyond the Rose person? And the answer was an unequivocal no, meaning that the Abby person lied, as I said they did. I know they did, because I went back and checked. They perjured themselves in their declaration. But not only did she commit perjury, the law firm itself was at best reckless, because how are you having her fill out a declaration when you should have seen the evidence, right? If she's saying she has it, why wouldn't you check it first? It's because they're just trying to survive summary judgment. That's the goal. I don't even know why. Like, they want to go to trial, I guess. I have no idea. I don't know what the goal is, but defendants argued that plaintiff would suffer no prejudice as a result of allowing Doe to proceed anonymously because plaintiff already knows Doe's identity. Finally, defendants argued that the public's interest weighed in favor of allowing Doe, this is the defendant, to proceed anonymously to prevent other victims of sexual harassment and assault from being deterred from reporting such behavior. Defendants, right? This is defendants when they're the defendant, right? Okay. Plaintiff opposed defendant's administrative motion. Plaintiff argued that Doe had not identified what harm she would suffer if made to proceed in her true name. Plaintiff argued that sexual harassment victims, as opposed to sexual assault victims, are not typically allowed to proceed anonymously. For this proposition, plaintiff relied on a number of out-of-circuit cases where the victim seeking to proceed anonymously was the plaintiff. Plaintiff also claims that he has the right to attack her credibility in public rather than her hiding behind a cloak of secrecy. Finally, plaintiff claims that he has the right to defend himself publicly, where there is a greater incentive for truthful testimony. Doe, as the accuser, has to proceed publicly so that other presently unknown witnesses may learn that it is she who has made these accusations and may come forward to provide information or evidence helpful to Professor Heinecke. The court found that in the circumstances of this case, Doe's interest in proceeding anonymously outweighed any potential prejudice to plaintiff. First, unlike the cases that plaintiff relied upon, Doe is not the plaintiff in this case. She is not the one who has chosen to avail herself of the public forum of the court. This quote has to do with the defendant. The defendant is not the one who has chosen to avail herself, meaning to make herself available of the public forum of the court, because she's being fucking sued in this case. So by the way, like I said, if you get bored, or if you do like Civ Pro, or if you're a law student, or if you're just bored or whatever, you shouldn't read any of my shit, obviously, whatever. But if you're ever bored, all of the underlying citations that they use in their case against me, I don't know if it's AI generated or whatever. That's a wild fucking quote to say right after my fucking name. Bonnell's contention, In fact, contrary to Bonnell's contention, courts have recognized that such protection applies especially to third-party witnesses, given that these witnesses have not, quote, chosen to avail themselves of the public forum of the quote, end quote. So one, witnesses do choose. They literally choose to sign an affidavit. Again, I've already said this. They're not under subpoena. They're not compelled to be here for some reason. They have chosen to avail themselves of the public forum. The one who hasn't chosen is me, the defendant, which makes sense because that's what this case is about. It's about the defendant proceeding under pseudonym. And it sounds like the defendant, because they're being referred to as Doe, unless that's actually the last name, won on that motion. The problem of anonymous plaintiffs involves considerations entirely different from those involving John Doe defendant. Second, there is no prejudice that result in plaintiff as a result of allowing Doe to proceed anonymously. That's especially true when plaintiff knows Doe's true identity. Third, plaintiff's assertion that exposure to the public is what incentivizes witnesses in court to tell the truth is contradicted by plaintiff's many filings in this court, which focus on the importance of testifying under penalty of perjury, not the importance of public testimony. Quote, I should be afforded the opportunity to show, if necessary, in court, where Doe will have to prove under oath with substantial credible evidence and sworn testimony from witnesses who are cross-examined that I did not sexually harass her. Fourth, because the court ordered the parties to refile all documents containing Doe's true name. With her name removed, all the filings in the case will be available for public review. Fifth, the court concludes that the public interest is served in allowing an alleged victim of sexual harassment to be sued under pseudonym to avoid deterring other victims from coming forward. As a result, the court granted defendants' administrative motion, sealed documents with reference to Doe's true name, and ordered the parties to refile those documents without Doe's true name. For the foregoing reasons, defendant's special motion to strike is granted in part and denied in part. Defendant's special motion to strike is granted with prejudice as to plaintiff's IEED claim against SCU and plaintiff's NIED claims against SCU. Defendant's special motion to strike is granted as to this, blah, 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 blah. Defendant's motion to dismiss the complaint in its entirety is, oh, wait. Oh, was the whole case dismissed here? Defendant's motion to dismiss the complaint in its entirety is granted as follows. Section 1983 and 88 claims are dismissed with prejudice as Doe or dismissed. Plaintiff chooses to amend the honor, he must file an amendment. The court declined to exercise supplemental jurisdiction over the remaining state law claims. As such, plaintiff chooses to amend. If plaintiff chooses not to amend these, the wrongful discharge reach under. Oh, so this whole case got dismissed on this hearing as well. And it was with the defendant proceeding under pseudonym for the filing of this case. Why would you? What a horrible citation. So they cited a case where the plaintiff lost, and they cited a case trying to pretend that it was about witnesses or people who are being forced to come forth to proceed under pseudonym, but it was about the defendant, and they lost the case, and the case was dismissed. Sorry, it's so cringe. I hate these people. When you say Doe, who are you referring to? Pixie is Jane Doe, because they filed to proceed under pseudonym because they're children. Because she's like, oh, I don't want my name to be revealed, despite the fact that she invokes my name constantly and other stupid shit. Jesus Christ. Much like in Planned Parenthood Arkansas and East Oklahoma v. Jegley, for example, plaintiff's prior draft protective order simply contemplates the type of umbrella protection often fashioned by courts, the opportunity for each witness to decide whether he or she wishes to disclose their identity. Like, if we were to go through each of these, probably every single one is absolutely fucked. Destiny, if an attorney cited a case like this at our firm, they would get fired. Kafka, they've done this shit constantly. Like earlier when they were arguing about filing under seal or whatever. Fuck, I wish I could remember exactly what it was. They were citing a case and it just had to do with it actually just had to do with proceeding under pseudonym. Like they mix stuff like this up constantly. It's just so stupid. If this gets to discovery, there's like a 25% chance the case. Oh, we're already in discovery technically. How is this legal? Let's say you're a normal person with a normal job. You would have to pay out your ass for a lawyer to scrub through all of their irrelevant spam citations. Well, I mean, I'm obviously being very careful on everything, but I mean, technically I could have a much cheaper law firm and I could just I could just say not respond much to the filings and just show up at court and try to do the civil case, but I found a way to upload it. You should share it. What is this? Wait, hold on. Logistical stuff. Should I watch this for the first time on stream? What is this?
Public covers death on defendant's YouTube channel. Attached here to as Exhibit B. In true, correct copy of this communication needs to
Jesus.
Wow, I'm so glad they've gone to great lengths to protect this person's identity. Exhibit B. Hold on, let me pull up Exhibit B here. They've gone to great lengths to protect this clearly heroic individual's identity. So let me just see. Oh wow. I don't know who this could possibly. You know what? I'm glad that they protected this person's identity. They could really be in a lot of trouble. This person's apparently been threatened. Whoever this person is could have been in a lot of trouble if their identity was exposed in any way. The name is redacted, yes. The name is redacted. The avatar is not redacted. Now, it was gonna be, like, let's be real, it's gonna be obvious who it was just from the, like, literally, like, the quotes, like, referenced earlier on, okay? Yeah, but I'm sorry, it's just very, very, very funny that, like, they're like, not saying the name, they're protecting the name. And I click on this, it's my shit. But, like, realistically, there's no reason to suspect, or, like, I don't need, I've said that to Pixie, but I told Pixie, I was like, I literally said, hey, I'm gonna talk about that on stream, and then I said it live, like, publicly, right? So, realistically, I want my identity protected, but I don't need, like, the pseudonym protected, is whatever, right? Yeah, I mean, I let her know, I was like, hey, just so you know, that should have definitely been censored, that would have been insane not to censor it. If it wasn't somebody who had spoken publicly, right? So yeah, it's like, if I've spoken publicly on it, this is me asking to speak publicly on it, right? I was gonna say, like, oh, I'm gonna say that on stream. Oh boy, but sorry, I had a little laugh to myself when I saw that, okay? I'm like, oh, thank God, they're protecting this brave, heroic individual. I don't believe that, by the way. Like, obviously, this guy's just unhinged, it's whatever. Anyway, sorry. It's a little funny, I was just like, hey, probably, you guys should, yeah. I mean, they probably just thought it was like some random picture or something, right? But it wasn't.
Why am I watching this?
Anyway,
or what is the point of this?
Potential witnesses also believe that the defendant has committed crimes against them by disclosing intimate images of them without their consent, but they are afraid of pursuing legal action because of how he's publicly harassed and insulted me and anyone who has supported me, including my counsel. Three of these witnesses have expressed to me their fear that their physical well-being could be put at risk if they attempt to pursue justice. Attached here too is Exhibit C is a true and correct copy of my conversation with one of these witnesses. It could have been. Oh, we're all good now.
Oh,
Bro, you can, like, can I turn the contrast up somehow? Fuck. It's just annoying as proceeding and ensure the process, protect the safety and privacy of the parties.
He, like, when he talks about this on stream now, he's like very, very, very adamant that he's in fear of his life. Like, he acts like he's legitimately worried that I'm signaling to people to show up and kill him. It's just fucking hilariously, stupidly unhinged, but... To the court, is this literally just a screenshot with some text on it, or do these people have to identify themselves in any way to the judge? Well, I mean, you have to... Well, no, if a witness is filling out an affidavit or a statement or something, then you have to... then they would have to make their information known to the court, right? To show up and testify and stuff like that, and to make statements under oath. Do I want to... We could just do all day civil procedure on my stream going over these cases. Does counsel normally get cross-examined, or is that just witnesses and stuff? Could Destiny's lawyers ask Doe to explain the sedation? It shouldn't be, although counsels are getting involved because they keep accusing mine of not doing meet and confers or whatever, but generally, no, counsel shouldn't be getting examined or cross-examined. That'd be weird, I think. But I mean, they could testify as to, like, some emails or something like that, right? Why does Justical hate you so much? There's always big public reward and pressure to do so. And it was obviously a really easy opportunity for him to flip. And then there's like a whole bunch of, like, a big community behind it to push it or whatever. But I mean, they never last long. I will say it's very funny watching Justical stream with, like, Kelly and Cherry, and he, like, very clearly hates both of these people and wants to go off on them, but he has to try very hard to be chill and not say anything crazy because he needs to keep these people around to, like, foster the hate for me. Like, there's been a ton of people that have, like, left his server, and he's, like, tried new rules. It's just very fucking stupid. It's, like, wacky as fuck trying to watch all these people trying to get along, shared, like, just kept together by their hatred of me, I guess. Considering how much fighting there is over meet and confer, it's possible lawyers might make statements on the record. I mean, they've already filed declarations and stuff, but I think Kelly said that it doesn't necessarily mean he's in fear of his life, but he could be in fear of losing his future job prospects, which is kind of ironic considering she's trying to get you to nuke his career. True, but also, what do you mean? Why would he be in fear? What, because he's telling a lie, or what do you mean? I don't understand that. Is it normal for one party to accuse the other of avoiding meet and confers this much? I mean, I would argue, with literally no fucking legal experience, but in my mind, it seems to be the goal of that is to try to set traps and to just play games with a legal system to fuck the other side up. Like, a court is genuinely, the court should just be here as a referee. We're arguing back and forth on some shit. We're trying to figure out what evidence at the end of the day are we going to get to show to a judge or a jury. And then in the process of that, that's what all the pretrial stuff is. That's what all the discovery stuff is. If we have a disagreement, then you and me are going to go to mom and dad, and we're going to say, Mom and Dad, is this fair or not? And then that's it. But it shouldn't be playing games with meet and confers and everything makes it seem like you're just trying to set stupid traps and you're playing games because you're not confident in your case or your material or your Fuck my last question. I'm typed it tagging us. Oh. Why does she hate you again? Not Kelly. The other person. Listen. I don't know. That's a whole other thing of yeah. Fuck. I don't want to. I can be here all day checking how stupid their filings are. But it also overlooks that these protections apply with special forces to cases calling for evidence of sexual related activities, as in the case at bar, reversing an order, denying a motion for protective order by party on behalf of third-party witnesses regarding sexual conduct. Like, I wonder what this case is about. In 1998. Oh boy. Fuck. Usually they're just supposed to pop up. Southern District of ALA is Alaska or Alabama? I have no idea. But that means it's a federal case? Can I look this up in Pacer? Actual brain blast moment. I feel like she would say because people would try to contact his potential future bosses despite those communities now doing this exact thing to you. Yeah, but I'm an evil person, so all behavior is okay. Oh wait, did somebody find it or have it? Hold on. Oh, no. When Lauren De Laguna made her allegations, she just said you recorded Farah. Juice Talk is not saying you recorded Jasmine and Lauren too. First of all, these recordings are audio conversations we've had because these people are crazy. Number one. Number two, no, I don't think I've ever recorded a conversation between me and Jasmine or Lauren. Not to my... No, I don't think I have. I don't remember that. But remember, one of the frustrating things is that these people can say anything. We're in a court environment now. If you want to say shit in court, say it under oath. We've got a judge here. We've got a court. We can plead things under oath. Do that. I don't know why I would make random statements online now. Join the case. Fuck. Can somebody find this? I'm just curious what this case is. Wheels versus Human Res Systems, Inc. Can I look this up? Oh, is this it? The burden of the non-party is particularly great when the party issuing the subpoena seeks private information. Non-party status is a factor courts may consider when analyzing whether a subpoena is unduly burdensome. It is generally accepted rule that standards for non-party discovery require a stronger showing of relevance than for party discovery. The burden on the non-party is particularly great when the party issuing the subpoena seeks private information. No one is seeking private information, and none of this is about a subpoena, though. This is about reversing an order, denying protective order. So, for example... Oh, but they're citing another case. I'm sorry, this wasn't it. This is a case they're citing. Fuck. Does anybody have a link to this? Is there a way to even find this case? How are they finding this case? $179 FRD. And then 635 and 639. This is like the volume at the end here or whatever. The case doesn't exist, it might be... No, the case exists because the case is cited And another thing. Oh, wait, somebody found it. The court listener. Thank you. Oh, that's the page number within the reporter. Okay. Jesus. Also, some of their citations are really fucking weird, but okay. Southern District, Alabama. Is that what? Is Florida the 11th Circuit? It is. And Alabama's part of us? We are. Okay. What? No, just show me that. Okay. Indeed. Okay, what are we at? Oh, they didn't even quote. They just cite it. $635 and then $639. Okay, this is the start of the case, I guess. And then they're citing to 639. Yeah. You know what? Fuck it. I don't care. Let me use the restroom. 1 second. Oh. Okay, well, so this is my life. I am reading this, so get fucked and be bored. I'm just curious what they're citing to. This was a case from 1998 in the Southern District of Alabama. Somebody asked if you have to cite from the same circuit. I don't believe you have to, but I don't think that cases from other circuits are considered precedents in the same way. If there's nothing that you can cite in your own circuit, I think you can cite to cases in different circuits as maybe guiding or whatever, but I don't think it's considered as strong as being able to cite to your own federal circuit. I just sent you the case on Discord. Thanks. I think I just read this, though. Okay. This action is before the court on the motion of the United States for a protective order. The motion was initially referred to the magistrate judge, but was then referred to the undersigned, the senior district judge, as an appeal from his determination. For the reasons set forth below, after conducting a de novo review of the ruling. So I believe that de novo means you're starting from nothing and doing a legal review of it. Yes. Okay. So you're not taking into account like, well, the lower court said this, so we kind of agree. You're starting fresh, basically. You're just doing your own legal review. De novo might mean new or something. I don't know. Fuck. Whatever. After conducting a de novo review of the ruling of the magistrate judge, the court will reverse that ruling and will grant the relief sought by the defendants. The United States for a protective order. Okay, so all right. Destiny Kudu, what? Another Iranian top official killed in strikes. Nice. Background. Plaintiff Eva Wheels initiated this Title VII action, alleging that she was sexually harassed during her tenure as a nurse practitioner at the Coast Guard's Aviation Training Center in Mobile, Alabama. In particular, she alleges that she was harassed by Ken Armstrong and Charles Skeers, and that she made the harassment known to Lieutenant Eric Starn. Starn served the Coast Guard as a supervisor at the Aviation Training Center. He is not a party to this action and is not accused of actual harassment, but he is conceitedly an important witness in this matter by virtue of his supervisory position. He denies the plaintiff reported the alleged harassment to him. Jeanette Waldrop was, during the relevant times, a co-employee of the plaintiff under the common supervision of Starn. Her testimony in this case is expected to corroborate Starn's and is expected to, by all involved, to be very unfavorable to the plaintiff's case. Like Starn, she is not a party to this action. On March 31st, 1998, okay, hold on real quick. Parties are only people listed as defendants and plaintiffs, correct? Like a witness, I believe, is not a party to a case, right? Kafka or... What is this? Oh, yes, what an interesting argument you make, Mr. Chair. P.S. This is for doing your lawyer's job on your own. Oh, I mean, they do their job well. But I like to be obviously I have an interest in legal shit as well. Where did the 3 lawyer people go in chat? Fuck you guys. I guess I can Google it. Westlaw. Parties. Party! Whatever. I'm pretty sure a party is just, oh, thank you. Oh, the Cornell one is good too. In legal parlance, a party is a person or entity who takes part in a legal transaction. For example, a person with an immediate interest in an agreement or deed, or a plaintiff or defendant in a lawsuit. A third party is, okay, parties in a lawsuit are the plaintiff or petitioner bringing the case, or the defendant or respondent defending against one. Okay, that's what I thought, okay. Witnesses are not considered parties to a case. All right. Just making sure on that. On March 31st, 1998, the deposition of Starn was commenced. It did not proceed for any great length of time. A short time into the deposition, the following exchange took place. By Mr. Mosley. Did you ever go to Jeanette Waldrop's home on Vista Bonita Drive in Mobile, I think. Yes, I've been there. Have you ever spent the night at Jeanette Waldrop's? Mr. Sawyer, objection. Have you ever spent the night at Jeanette Waldrop's home? Mr. Sawyer, objection. Don't answer that. For the record, I'm instructing the witness not to answer. It's not relevant, and there's no need to get into that. I don't believe you can tell a witness to avoid answering because of relevancy, but okay, I don't know. It certainly is relevant. Well, I'm instructing the witness not to answer. Well, we'll have to go to the judge. Well, then go to the judge. The parties then held a telephone conference with the magistrate judge. The magistrate judge ruled the question propounded by Mr. Mosley was proper and that the witness must answer. Counsel for the federal defendants immediately announced his intention to seek relief from the district court and terminated the deposition. The parties have fully briefed the issue before the court, and the issues joined are ripe for adjudication. Okay. Ripe, I believe, in this sense means that the appropriate channels have been exhausted, so now they're looking at a higher level court, I guess, to figure out the answer to this. Legal standards, generally speaking, federal rules of civil procedure grant a party seeking discovery a very wide path down which he may foray in search of all information favorable to his case. In the absence of a court order, information is deemed discoverable if it is relevant to the subject matter involved in the pending action. The information sought need not be admissible at the trial if the information sought appears reasonably calculated to lead to the discovery of admissible evidence. However, when a party's discovery efforts are more invasive than necessary, the rules also provide a remedy. On matters relating to a deposition, the court may make an order which justice requires to protect a party or person from annoyance, embarrassment, oppression, or undue burden or expense, including one or more of the following. And that certain matters not be inquired into, or that the scope of the disclosure or discovery be limited to certain matters. This makes sense, right? So imagine you have the right, or imagine you get to do a deposition on somebody's friend who has information about some way that they were wronged by a defendant in a case. And as you're talking to that friend, you're like, isn't it true that you sucked dick and were a prostitute and gambled and cheated on your husband? And it's like, this has no relevancy to this case at all. And two, this is incredibly invasive and you don't need access to this information, right? So it makes sense that there would be rules that would protect, say, witnesses' rights when it comes to answering questions and being witness to a case, right? That makes sense that would exist. They're not even parties to the case, right? Setting Federal Rules of Civil Procedure 26C. On a motion invoking that rule, this court is called upon to undertake a careful balancing of all relevant matters. The Court of Appeals for the Seventh Circuit has stated, so here they're talking about a different circuit, right? So they can talk about what other circuits have ruled. A motion under Rule 26C to limit discovery requires the district judge to compare the hardship to the party against whom discovery is sought, if discovery is allowed, with the hardship to the party seeking discovery, if discovery is denied. He must consider the nature of the hardship as well as its magnitude, and thus give more weight to interests that have a distinctively social value than to purely private interests. And he must consider the possibility of reconciling the competing interests through a carefully crafted protective order. So what this means, and people seem to forget this, especially Pixie and everybody involved, because to them, all of this is just a giant fucking meme shit post on the internet. But when it comes to big boy court, when we're in court, we're not talking about like internet screen names and Discord DMs and all of this like cutesy shit. Now we're in a court where there is a public interest for justice to, prevail, that the public has an interest in knowing what is involved in this process. They have an interest. There's a public interest in seeing who are the witnesses. There's a public interest in seeing who is the plaintiff, who's the defendant, what are the questions being asked, what are the filings. All of us have an interest in this because we'd like to be able to cite to it. If it's a strong case, you want to be able to reference it. The credibilities of all these people are on the line. Sometimes there are big boy penalties. Sometimes this stuff could even be used later on for criminal stuff, depending on how badly a case could go or what comes out or whatever. So we all have an interest in this. However, there also are privacy interests for some of the people involved. Some of the information can be humiliating, especially when you're talking about sexual stuff, especially if you're talking about minors, especially if you're talking about stuff that might not be directly related to the case. So what this is saying is the judge, must consider the nature of the hardship, meaning how much is it going to fuck over somebody seeking information to validate their claims, right? He must consider the nature of the hardship as well as its magnitude, right? How big of an impact will this have on the case? And thus give more weight to interests that have a distinctively social value, meaning you have to give more weight to the public interest, distinctly social value, than to purely private interests. It's not enough to just be like, don't dox my name. I don't want my name to be out there. Then you shouldn't be involved in a court case. These are public matters. These are public proceedings now. These are public filings, right? If you don't, and you want to hide your name, then you have no business. This is not the forum for you. You shouldn't be in the legal forum. You should go somewhere else. That's what Twitlongers and Substacks are for. And you must consider the possibility of reconciling the competing interests through a carefully crafted protective order. A protective order could allow somebody to pursue discovery while still keeping some information private from the public, right? Would be what a protective order might be for. So for instance, proceeding under a pseudonym. Plaintiff in my case is Jane Doe. I know who she is. The public doesn't have access to her name. Now, for a whole bunch of other reasons they do, but that's because plaintiff is retarded. But this is the balancing act, I guess, you have to do when you're filing or when you're trying to construct a protective order, right? To state the matter more concretely, this court must balance plaintiff's need to inquire into the sexual conduct between two non-party witnesses against the non-party's legitimate interests in privacy, meaning witnesses for the defense, I guess. If the requested relief is granted, the court must carefully tailor its order so that the plaintiff's access to legitimate areas of discovery under Federal Rule Civil Procedure 26 is curtailed no more than is necessary. Oh, this is blocking. This isn't just for a protective order, though, like to proceed under pseudonym or for filing under seal. This is to block off an entire area of questioning, though, I think. So this is even stronger for what they're going for, or it's a different thing. Discussion. Plaintiff's need for the information sought. Plaintiff seeks to inquire into the possibility of a sexual relationship between Starn and Waldrop for one reason only. She believes that evidence of such a relationship would prove that Waldrop is a biased witness because she would tailor her testimony to maintain the good favor of Starn. The court notes initially that this is a rather attenuated claim of bias that the plaintiff is raising. The worst act or omission of which Starn is accused is that plaintiff reported acts of sexual harassment to him and did not take sufficient actions to stop the harassment. Starn himself is not accused of harassment. Waldrop's worst possible testimony could not, therefore, paint Starn in too unfavorable a light and could not result in his personal liability. On the contrary, Starn has little or nothing to gain personally from Waldrop's most favorable testimony. Therefore, the plaintiff has articulated little or no reason why Waldrop would tailor her testimony to favor Starn or to disfavor the plaintiff. The plaintiff, therefore, will not be greatly prejudiced by a limitation on the discovery that she presently seeks. The plaintiff, therefore, will not be greatly prejudiced by a limitation on the discovery she presently seeks. Okay. So saying that you haven't put forth a good argument to say why you should be allowed to ask these questions, because even if both of these witnesses answer the most favorably possible to you, it still doesn't really help your case much. Moreover, what little prejudice the plaintiff will suffer may be curable by stipulation. Counsel for the federal defendants avers that Starn and Waldrop are willing to stipulate to certain facts which plaintiff may be able to use in order to question Waldrop's testimony without probing into the intimate sexual matters of these non-parties' private lives. Defendant's interest in discovering information from which bias might be inferred was mitigated by availability of other evidence from which equivalent inference might be made. Indeed, plaintiff herself does not purport to seek intimate details of Starn and Waldrop's alleged affair. During the telephone conference with the magistrate judge, which was held during Starn's failed deposition, counsel for the plaintiff stated, "The only thing I want to know is if they had an affair, and they can either deny it or not. That's the only thing I want to know. I don't want to know anything about their sex lives. Other than that, they're adults, we're adults, and I'm not going to ask anything like that." Starn deposition at 70. If this is truly all plaintiff wants to know, then the witnesses are apparently willing to agree to as much. Witnesses' interest in privacy. So this is probably especially interesting to us. Against the plaintiff's interest in gathering information to prove her case, discussed supra. Does that mean above? Sorry. Against the plaintiff's interest in gathering information to prove her case, the court must weigh the non-party witness's right to be free from unreasonable inquisition into their private lives. Okay, sorry. At the outset, the court must express its categorical rejection of the notion, alluded to by the government in footnote 6 of its brief, that any penumbra eminent far enough from the due process clauses of the Constitution to embrace any constitutional right to engage in the alleged acts about which the plaintiff seeks to inquire. Jesus. Penumbra eminent. Far enough from the due process clause. Hold on, let me reread this. Okay, at the outset, the court must express its categorical rejection of the notion, alluded to by the government in footnote 6 of its brief, even number eminent far enough from the due process clauses of the Constitution to embrace any constitutional right to engage in the alleged acts about which the plaintiff seeks to inquire. Kill me. Eminent by penumbra. Okay. Fuck me. My guess is that the government tried to argue that if it's not like strictly in the due process clause of the Constitution or something, then it doesn't count as being protectable or something, maybe, is my guess. That's my guess, I don't know. Such effusive emanation would be better characterized as unlawful encroachment on the traditional police powers of the several states. See U.S. Can I get the sound of statutes constitutional? The court's holding is in no way based on any constitutional right other than perhaps that fundamental one to be let alone, the most comprehensive of rights, and the right most valued by civilized men. Starn and Waldrop's rights to be let alone are recognized and given expression in federal rules. Okay. Emanate, it's a verb. Penumbrae is plural. Okay. While judicial emanation is to be eschewed, it must be recognized that Starn and Waldrop certainly have legitimate interests in privacy regarding their personal affairs, whether or not the court or the state condones the alleged subject matter of the same. In this litigious age, their interests are heightened given that they are engaged in at least a quasi-military enterprise. Their privacy interests are further bolstered by the fact that neither is a party, neither Starn nor Waldrop is voluntarily involved in this lawsuit. Ooh, not voluntarily involved in this lawsuit. And as far as the record shows, neither is guilty, as that term is naturally understood, of any malfeasance by which they invited themselves to be involved in this lawsuit. Balancing of interests. Having fully considered all of the above matters, the court concludes that the witness's interests in maintaining the privacy of their intimate relationships outweighs plaintiff's interest in invading it. Plaintiff essentially seeks to ask Starn and Waldrop whether they have ever engaged in sexual intercourse. She believes that evidence of a sexual relationship with Starn will discredit Waldrop's adverse testimony. As discussed above, the court finds this claim of bias rather weak and the witness's interests in privacy rather strong. Therefore, the court holds that there is good cause to limit the scope of the depositions of Starn and Waldrop in order to protect the deponents, meaning people who are doing a deposition, from annoyance, embarrassment, and oppression. Other courts have reached, this is 639, okay, other courts have reached similar conclusions, particularly some of the In that case, a sex harassment plaintiff sought to depose certain non-parties who were not accused of contributing to the alleged hostile work environment. Defendant Kmart, on behalf of the non-party deponents, sought a protective order that any voluntary romantic conduct or sexual-related activities of the witnesses not be inquired into during deposition or other discovery after examination of that particular lawsuit. The court has previously made reference to the cases of Farnsworth v. Procter and Gamble. Oh, is that where they ripped that reference from? They just took it from this when they found it? They are mentioned again as cases which preponderate in favor of this court's decision. This court now turns in its final task in resolving the present appeal. Based on the Foregoing balance of interest, the court must carefully craft an order which channels plaintiffs' access to discovery no more than necessary and reconciles the competing interests to the greatest possible extent. In this connection, a distinction must be drawn between the annoyance, embarrassment, and oppression that opponents will suffer merely by virtue of having to answer questions about their sexual lives, and the annoyance, embarrassment, and oppression they would suffer by virtue of the disclosure of that information to third parties not involved in this lawsuit. The court concludes that the plaintiff has no more right to the information sought than anyone else. Accordingly, the opponents should be shielded from the unwarranted intrusion in the first instance. Therefore, Starn and Waldrop will not be required to answer questions regarding their sexual lives, as set forth in greater detail below. Counsel for the government was correct in instructing Starn not to answer the pending question and did not wrongfully terminate his deposition. Damn, okay. Okay, sorry. So coming back here, I'm just curious. Bonnell also overlooks that these protections apply with special force to cases calling for evidence of sexual-related activities, as in the case at bar. C. Wheels versus Human Resources Systems, Inc. Okay. Reversing an order, denying motion for protective order by party on behalf of third-party witnesses regarding sexual conduct. Indeed, the revised Rule 412 of the Federal Rules of Evidence now applies to all types of sexual misconduct cases and expressly extends to third-party witnesses. See Stallnaker and Kmart. Oh, and that with that case was referenced in here as well. Against Kmart here. Under these safeguards, courts have held, for example, that third-party testimony about romantic or sexual relationships is highly sensitive in nature, and that disclosure of the witnesses' identities within their communities would expose them potentially to harassment, embarrassment, or stigma. Well, but this case had nothing to do with exposure of identities. This case just had to do with what questions could be asked during a deposition. None of the cases they ever cite ever match anything well, but. Nature, okay. Voice of San Diego v. Naval Criminal Investigative Service. I wonder what this case was about, because this seems to be the most relevant one. Within their communities would expose them potentially to harassment, embarrassment. I wonder if this had to do with disclosure of an identity. Blah 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 blah. So they're basically citing a case and just attaching the one cited to it to make their own case look more legit. Yeah, it's kind of like when you Wikipedia an article and then you like just cite all the sources at the bottom, I guess. Or maybe these are very commonly cited cases in this, although I would be surprised given how little relationship they seem to have to my own case, but. Regarding suicide note/journal entries that consist of the descendants, or the decadents, the decedents? Decedents? The fuck is decedent?
Decedent.
Oh, a person who's deceased, who's died. Regarding suicide note/journal entries that consist of the decedent's suicide note or journal entries, the court has no trouble in concluding that the decedents and their surviving family members have the strongest privacy interests in both the suicide note and the journal entries. The requested suicide note would intrude not only into the memory of a deceased loved one, but more specifically into the intimate and private relationship between the decedent and her family members. Similarly, the writings of a decedent in the days leading up to her suicide are likely to contain personal information, like entries related to possible suicidal ideations and notes apologizing to family members. The decedent and their families have the strongest personal privacy interests in such matters. Third parties also have strong privacy interests in the journal entries describing their relationship with the decedent. Disclosure of these entries reasonably could allow their identification within their smaller communities, subjecting them to unwarranted pain, embarrassment, or stigma, either from the content of the comments or the connection to the suicide investigation. And they cited that as Under these safeguards, courts have held, for example, that third-party testimony about, quote, romantic or sexual relationships, end quote, is highly sensitive in nature and that their disclosure of the witness identities, quote, within their communities would expose them potentially to harassment, embarrassment, or stigma, end quote. This was about diary. Wait, is there another quote in this that I'm missing? This has nothing to do with romantic shit. This has to do with fucking shit written in a diary about a guy that killed himself. What the fuck? Am I missing something? Was there something else that they're citing to that I'm missing? Potentially to harassment. Control F. Potentially to... Oh, wait, hold on. Maybe this isn't the right quote. Maybe there's something else? No results found. They fucked up quotes before. Did they fuck their quote up? Is this not a real quote? Did they just make this up? Quote, within their communities would expose them to potentially to harassment, embarrassment, or stigma. Control F, stigma. Disclosure to these entries reasonably could allow their identification within their smaller communities, subjecting them to unwarranted pain, embarrassment, or stigma. Would expose them potentially to harassment, embarrassment, or stigma. Do they have a translated document or something? Or what's happening here? Is there another quote that's incredibly similar but uses a different adjective instead of harassment? Unwarranted pain? (753F). Is there a way to see like the page that this would have been published on, or they're trying to make it fit for this case? Yeah, but it clearly doesn't. Also, I would argue this isn't even misleading. This is a lie. They're saying under these safeguards, courts have held, for example, you're saying third-party testimony about, quote, romantic or sexual relationships, end quote, is highly sensitive in nature, and the disclosure of the witness identities, quote, within their communities would expose them potentially to harassment, embarrassment, or stigma, end quote. But this last thing, I don't think has to do with romantic or sexual relationships. It has to do with entries in a diary from a person who fucking killed themselves. Maybe they're talking about romantic parts and some other here? Oh, they pulled it from a later quote. Hold on. For this far down, romantic. They pull it. Okay, next, the court relates that defendants have categorized 5 of the items in the Vaughn Index as pertaining to intimate and sexual information, which includes information about or conveyed during the course of a decedent or a third-party witness's intimate, romantic, or sexual relationship. Within these 5 items, defendants have asserted privacy interests on behalf of the deceased service members, their families, third parties. These are dead people. The court finds that, as discussed above, the fact of death diminishes but does not eliminate individuals' privacy interests, while the court is unaware of a Ninth Circuit decision expressly holding that deceased individuals have privacy interests and their own criminal records. The court is mindful that the mention of an individual's name in a law enforcement file will engender comment and speculation and carries a stigmatizing connotation. Additionally, one court has concluded that the deceased defendant never convicted of a crime. In light of these guiding principles and the absence of arguments or evidence from plaintiff that the law enforcement contacts here already know to the general public, the court agrees with defendants the disclosure of these records would implicate measurable privacy interests that decedents retain in their criminal histories and prior encounters with law enforcement. Okay. Jesus. Okay. These must be chat. I wonder if there's like chat GPT summaries for cases. I wonder if that's where they get these from. Finally, there's no support to Bonnell's insistence that the plaintiff failed to meet her evidentiary burden to show good cause, as other courts have concluded under similar circumstances that third-party witnesses wish to remain anonymous based solely on their representations to that effect to the moving party. See, Alaska actions on toxics versus Aurora Energy Services. Rejecting defendants' standing argument and observing that the anonymous individuals here have indicated to plaintiff's representative that they wish to remain anonymous. noting that other courts have entered protective orders barring the disclosure of the identities of individuals submitted information anonymously and protecting the identities of individuals who would like to be subjected to the rest of the close submitted information anonymously. Well, these are about specific witnesses coming forward testifying to specific and explicit information, not. I'm okay. I'm not going to look up all of these. My guess is if I look up this, it also is something that has absolutely nothing to do with the type of case here, but. Okay, whatever. All right, I'm good with this for today. Tellingly, none of Bonnell's cited cases involve allegations of sexual misconduct, such as cyber harassment. Yeah, because you guys haven't even put anything in the record to show any evidence of me engaging in cyber harassment. What the fuck? Against plaintiff? As such, each case Bonnell relies on is inopposite and unpersuasive. Bonnell's citations to the line of cases declining to permit anonymity cuts against his position, given that this court has already found that this is that exceptional case where the plaintiff may proceed under a fictitious name. It's not an exceptional case where the plaintiff may do it. The statute literally carves out proceeding under a protective order. And her witnesses may submit declarations under seal without public disclosure of their identity. Where is that that's not in the statute. See Doe v. Frank. Case involving allegation or discrimination on the basis of alcoholism. Were all the witnesses anonymous in this one? Doe v. Frank. It was 92, so it's not the same law, but was there cyber harassment in 1992? Cited at DE 92 at 3, 5, and 7. Let's see. Opinion of the court. We also see no error in how the court addressed Doe's concerns over alleged fear of prosecution, the third step one factor. District court found that any sexual intention related to Doe's drug use. Moving to the second factor, potential selection. We cannot say the district court abused its discretion. Doe ends by cautioning that affirming the district court would likely result in no Title IX litigant being able to proceed anonymously, citing a case from the First Circuit he believes supports reversal here, but we agree with the First Circuit that the confidentiality of a Title IX disciplinary proceeding may sometimes, but not always, furnish grounds for finding an exceptional case warranting pseudonymity. As shown here, the district courts in our circuit are more than capable of balancing plaintiff's privacy interests against constitutional rights to access judicial proceedings. And district court thoroughly reviewed the circumstances presented to it and made no clear error in judgment when denying Doe's motion. The order denying the motion to proceed anonymously is therefore affirmed. The order denying the motion. Wait, is this a loss that they're citing? Am I misunderstanding this? Wait, hold on. Wait, bro, I don't want to read anywhere this. Wait, hold on. I must be misunderstanding. Tellingly, none of Bonnell's cases are Bonnell's citations to the lines of cases declining to permit anonymity cuts against his position, given that this court has already found that this is the exceptional case where the plaintiff may proceed under a fictitious name, and her witnesses may submit declarations under seal without public disclosure of their identity. See Doe v. Frank. But in Doe v. Frank, the order denying the motion to proceed anonymously is affirmed. They lost that motion. So why would you cite the argument here? Doe hasn't demonstrated the district court abused its discretion when it found that any alleged social stigma Doe will face didn't outweigh the presumption that his proceeding should be a public one. Put simply, he does not cite any evidence of these harms and instead only asserts in briefing that they are nearly certain to occur. He says, noting that the plaintiff offered several documentary exhibits to bolster their assertions that they might be subject to retaliatory harassment or violence if their identities were publicly revealed. Affirming denial of motion proceed anonymously even where 3 plaintiffs submitted affidavits in support of the alleged harms. This was, and they were citing here, affirming the denial of motion to proceed anonymously, even where 3 plaintiffs submitted affidavits in support of the alleged harms. But what's... Am I... Zip zip. Are you illegal mode? Oh, maybe. Did they just look up like all the laws or all the lawsuits that were denying or reversing their shit and then try to cite them as arguments for their own? They are claiming that the court has found that their case was that exceptional case, unlike the cited one. But exceptional how? What are they citing to in the docket where they said this is an exceptional case? They applied to proceed under pseudonym because that's explicitly granted by the statute. The statute says nothing about your witnesses proceeding under pseudonym, and we didn't even oppose that, that filing. So when did the court find, where is this, quote, exceptional case coming from? Fuck, what is the name of this stupid fucking law? It's not a stupid law, I shouldn't say that. Protection, Transmission, Images Act. This code, fuck, what is it? What is the... Read the bonus meme in that message. Read footnote 5 in plaintiff's doc. 5. At no point has Bonnell disputed that he threatened plaintiff and her witnesses with physical harm in retaliation to their allegations and testimony in this action. Excuse me, what? Who? What? There are 3 witnesses to this case. When have I publicly threatened physical harm to any of these people? What? Or that he publicly harassed and ridiculed plaintiff's legal team. Yes, I am publicly ridiculing you. Harassment? What is it, harassment to read your retarded fucking filings and make fun of them? In light of the standard language of plaintiff's proposed protective order, there can be no explanation for Bonnell's objections thereto, other than that Bonnell intends to continue to threaten and harass plaintiff, her fact witnesses, and her legal team. Oh my fucking God, dude. Didn't you say some crap about Gesticle? First of all, that wasn't a private interview to Willie Mack, number 1. I didn't publish that. Number 2, Gesticle's not a witness to this case. Number 3, this is plaintiff and her witnesses. Did they even formally accuse you of that? Well, they throw it in all their fun. Like, this is retarded. Like, I don't even want to, like, participate in this. Like, this just feels stupid. Is this, fuck, I'm probably gonna send a big email asking about it. Because, like, this is just, they're shit posting. Like, this is so dumb. I've got to pay $20,000 to respond to this motion while they make shit up with ChatGPT and shit post at me. Like, a bunch of people that shouldn't even be allowed to appear in a fucking federal court. Like, let alone try a case like this. They clearly have no experience in this realm. In anything. Like, this is so unhinged. Every single case I've looked up either doesn't support their claim or cuts against them in the exact opposite. In this one motion. That doesn't include all the other random shit that I've looked at for... Equally unpersuasive are Bonnell's remaining case citations, as none involved remote... Oh, and now, what, are they focusing on our citations now because they're mad that I called them out on their shit citations? This involved different circumstances, whether anonymous affidavits were sufficient to support the plaintiff's trade secrets claim in summary judgment proceedings. Nice. By contrast, it is well settled that particularly in sexual harassment and other sexual misconduct cases, it is entirely proper and common for a plaintiff to rely on confidential witnesses. Eckhart versus Fox News lawsuit LLC. I wonder what this one says. Fuck me, fuck me, fuck me. Let's see what they say here. Yeah, you can't put things in quotes that aren't being quoted from somewhere. I don't know where that quote exceptional case comes from. And they don't source anything on the docket where that filing would say, quote, exceptional case, end quote. I want to know where this quote comes from. I'm very interested. Wait, it was in here. Entirely proper and common. Are they... Can you... This is not correct, is it? Wait. It is entirely proper and common for a plaintiff to rely on confidential witnesses. And they cite a case, but it looks like this quote is not from this case. It's from another case. Is that... am I reading this right? By contrast, it is well settled that, particularly in sexual harassment and other sexual misconduct cases, it is, quote, entirely proper and common for a plaintiff to rely on confidential witnesses, end quote. The case being cited is Eckert v. Fox News Network. And then I'm looking up this case of Eckert v. Fox News Network. And then I'm looking for the quote, entirely proper. That quote is not from this case, though. That's a quote that they quote from another case. Plumbers and Pipe Lifters Local Union. What, am I... Henry urges the court to conclude that Eckert abused the judicial process by including allegations by several anonymous women in her complaint, including one that has since been retracted in part. Blah, blah, blah. Regarding the anonymity of these accusers, the court finds no ground for sanctions, for it is entirely proper and common for a plaintiff to rely on confidential witnesses in a complaint. With respect to the allegations that have been retracted, the court notes that the veracity of those allegations is a question of fact that remains unresolved. Let's see, sanctions. So these were for asking for sanctions. Henry asked the court to sanction Eckert and her counsel pursuant to its inherent authority. As Henry rightly notes, federal courts possess certain inherent powers, including the ability to fashion a... Okay. Henry urges the court to conclude that they abuse the judicial process by including allegations by several anonymous women in her complaint, including one that has been retracted in part. Henry, regarding the anonymity of these accusers, the court finds no ground for sanctions, for it is entirely proper and common for a plaintiff to rely on confidential witnesses in a complaint. In a complaint. Does this mean for the court case, or does this mean just for filing the initial complaint? That's what that sounds like. Because plaintiff still purports to have good faith basis to believe the allegations are true, the court cannot conclude at this time the plaintiff's failure to remove them from the complaint upon their retraction is sanctionable. Is sanctionable? Let's look up this case. Fuck me, dude. Oh my God. Common. Fuck. Wait, where's a quote for this? It is entirely proper and comfortably rely on confidential witnesses in a complaint. Confidential. Okay. What? Confidential witness in a complaint. Where is this quote from? In a complaint. This is for document 80. This must be they're citing from a different. I guess. Stop. Stop. Fuck, this isn't the right document. On the top of that site, you can look back on the case. For this? Oh, bro, I have no idea what filing I would want to look at, though. Regarding the anonymity, okay. Or no, wait, I can't look at their quote. Oh no, wait, I can. This doesn't say, it says 278 FRD 335 341. These are like pages published, but it doesn't say the Oh my God. Am I able to search for... I just want to know what they're even citing here. Entirely proper. That's what we're looking for. Entirely proper. Oh, okay. Here we go. In holding that the confidential informant's names in this case are not entitled to work product protection, the court is finally mindful the plaintiff has utilized the confidential informants offensively by attributing extensive factual allegations to the 11 CIs and the SEC. Plaintiff buttressed its complaint, presumably with the goal of protecting it against dismissal. It is, of course, entirely proper and common for a plaintiff to rely on confidential witnesses in a complaint, and attributions to such witnesses may and often are credited, and attributions to such witnesses may and often are credited on motions directed to the pleadings. But once the discovery phase begins, the balance of interest shifts. The priority becomes reciprocal and robust fact gathering as the parties seek to discover relevant information. The parties enter, okay, so this has to do with, it was just for the complaint. This has to do with stuff listed on a complaint, not once we're in the discovery phase and everything. Oh, Jesus, okay. So they cite a case. God, dude, I'm sorry, done. Fuck. Okay, this is the last one. All right, I'm done. This is my last. I'm not going for any more of this. This is a waste of fucking time. This is so fucking stupid. So their sentences. By contrast, it is well settled that, particularly in sexual harassment and other sexual misconduct cases, it is, quote, entirely proper and common for a plaintiff to rely on confidential witnesses. So one, they're citing the wrong case because the lawyer is a fucking hack, okay, who should go back to Puerto Rico and only write there, okay? Number one. Number two, the case that you're citing here isn't talking about particularly in sexual harassment and other sexual misconduct cases. So I don't know why you would be citing it here, okay? Number three, the quote that you're citing from has to do with confidential witnesses on a complaint. Now, they had some confusion in court as well, I know, during our, when I was giving testimony, okay? And the plaintiff seems to be confused that a complaint is the first thing you file to begin proceedings on a lawsuit. A complaint is not just an utterance where somebody's complaining about something. A complaint is an actual thing that means something in court. So can you have confidential interests or confidential witnesses in a complaint? The first thing you file to start a lawsuit seems to be the case that yes, but we're not at the complaint stage. Not only are we not at the complaint stage, the underlying cited case literally says that it is, of course, entirely proper and common for a plaintiff to rely on confidential witnesses in a complaint. Now, remember, for Pixie's law team, that's the first thing that you file to start a lawsuit. That's the very first thing that you file, okay? And attributions to such witnesses may and often are credited on motions directed to the pleadings. But once the discovery phase begins, that's where we're trading stuff. Like when you asked me for like interrogatories and then we request like certain like cooperation subpoenas. Now that's the discovery phase. That's what we're in now. We're discovering information about each other to find out what can help our cases, right? Okay. Once the discovery phase begins, the balance of interests shift. So while the interest might have been on your side, now the balance is shifted to my side because we have a thing called civil rights in the United States. The priority becomes reciprocal and robust fact gathering. Robust, okay, meaning the ability to cover a lot of ground. Robust, very, a lot of stuff, fact gathering, as the parties seek to discover relevant evidence, like the names of people that you are alleging are witnesses to your complaint. The parties' interrogatories, you might remember that word because you put it on the page when you asked me for interrogatories, and we sent it to you for interrogatories, questions that you might answer as the beginning part of discovery. The parties' interrogatories, including interrogatories aimed at helping the propounding party assess which witnesses are most likely to produce or to possess probative admissible evidence, are an integral part of this process. And this doesn't even have to do with keeping these sealed from the public. This just has to do with a confidential witness. This is just retarded. Destiny, they aren't citing the wrong case. You can cite a case that quotes another case. I don't believe you. I don't believe you, and I would need you to show me exact evidence of that being the case written somewhere by somebody. I don't believe you otherwise, because that is fucking retarded if that is the case. In the court's view, where a party has attempted to satisfy the pleading requirements of the PSLRA by showcasing statements from a limited number of confidential witnesses, it may not thereafter refuse to disclose who they are on grounds of work product. Partial disclosure of information protected by the work product doctrine may constitute a waiver, and a party is not permitted to use such doctrines as both a shield and a sword. Just as the attorney-client privilege cannot be used as a shield and sword, neither can a worked product document. Product is like part of the thing that you produce as part of discovery, especially one that does not include an attorney's impression, opinions, or strategies, so just stuff from a witness. This is fucking retarded. Oh, God. Their filings read like Norm Finkelstein's book in regards to citations. Norm Finkelstein's, oh yeah, his books, that's right. I was going to say, Norm Finkelstein's court case is fine because I think he files those as a, oh no, he doesn't. I was going to say, I think he files those per se, like he represents himself, but I think he does have a lawyer. Yeah. I'm assuming you don't want to wait until December for discovery to end and a summary judgment to be issued. Is there anything you can do to speed up or force it? Is it really December? Is that when discovery ends? Fuck me, dude. Then fuck me, I guess. Fuck me in the ass. It's a good job. Great one. The problem is you don't want to issue, you don't want to ask for summary judgment prior to that. I think one is because it looks bad to the judge, like you're trying to end it prematurely. And then two, plaintiff has already demonstrated her willingness to blatantly fucking lie and then cover up all of the fucking lies by abusing the court system against me. So it's possible that if we do a summary judgment, that they go ahead and they fabricate another witness to make some shit up in order to keep the case alive for whatever reason. Oh, this is in the... Like here, they're quoting this one case again, Heineke versus Santa Clara, about protecting plaintiffs. But this case also, the filing here was about protecting the defendant, where the defendant filed, right? Or am I thinking, or was that a different? Maybe that was another case they filed up here, or they referenced up here. I don't remember now. Okay. Did you see how she omitted the last part of the quote? What? Entirely proper and common for a plaintiff to rely on confidential witnesses. Confidential witnesses in a complaint. Oh, they cut out the whole and attributions to such witnesses may and often are credited. Credited meaning their identities are revealed on motions directed to the pleadings, correct? Am I understanding that correctly? They did cut out that part of the quote. It's given leeway by most judges, but it's definitely not standard practice to change the text between the quotation marks. They've done paraphrasing. It's given leeway, not when it's changing. I imagine it might be given leeway as long as you're not changing the meaning of the underlying thing. They are credited as in they are assumed to be true for motions to dismiss. Oh, okay, that makes sense, and that would also explain why the balance changes once you're past the pleading stage, right? They're credited as in when the defendant, the respondent, files a motion to dismiss, all of the statements in the complaint are assumed for purposes of dismissal to be true. The judge doesn't weigh the evidence; they just read it and basically assumes everything to be true. Okay. Blue book question. How to cite when there are 3 levels of quotes? I have a citation that is rather difficult. Case A quotes case B, which quotes case C. I need to cite case A. The text I want to quote looks like this. The court agrees with case B, which stated that blue booking is hard when you have to look up really obscure rules that seem to be purposefully confusing. Case B, quoting case C. 2 questions. How do I write the actual citation? Is it proper for me to cite it like this? Case A, quoting case B, quoting C. How do I deal with the internal quotes? Do I keep all of them? Do I get rid of all of them? Well, I think that this is a fundamentally different question. I don't know whoever's looking at this, if you're looking at this. Like, quoting a case, citing another case, I think is different than quoting a case and just having the quote to that case when the full quote is literally just a quote from another case. I think it's a fundamentally different thing. Do I keep all of them or do I get rid of all of them? I know I'm normally supposed to get rid of quotation marks if it is at the end of a quote, as is the case here. Rule 10.6.3. Only one level of quoting is required. So case A, quoting case B. If the cases are controlling authority, it is probably best to cite the original source where possible. So the original source would be the bottom level case. So if case A is quoting case B, you would just quote case B. Yes, this is correct. Rule 10.6.3. And I'm like, no, however, then only one level. Thus, if the case quotes a case that itself quotes another case, only one level of quoting or citing parentheticals is necessary. An additional level of parenthetical information may be used. The information conveyed is particularly relevant. She cited it wrong, but it's a legit use of quoting common phrases, dipshit. Why are you talking about quoting common phrases? We're not writing for your Facebook. Is it possible that she knows that she has lost, so she's literally just trying to rack up your legal expenses? Yes, that is exactly what is happening. And she admits, I would argue, they admit to as much in the transcript. But that's why they moved to seal that transcript, because they know that that transcript, at least publicly and legally, I would argue, crucifies the fuck out of them. But that's why they moved to get that sealed so fucking quickly. So you're not able to quote anything from the transcript at all? I mean, I can talk about, like, I reread it, so I remember a lot of funny things in there. The cup of water analogy was fucking hilarious. Yeah, I don't know. What are the repercussions if your transcript got leaked? I don't know, but the thing is that right now, like our behavior has been perfect. Everything has been above board. So if I were to decide to just break from procedure here and say, fuck it, I'm just going to read the transcript because fuck these people, it would give them the first legitimate thing to kind of grab onto. Can you read the cup of water thing? Well, basically the judge is, in my opinion, I don't want to mischaracterize anything the judge thinks or ascribe any thoughts to him that he may or may not have. Obviously, it's the holy magistrate judge. His thoughts are his own. But the impression that I got was that the judge was kind of figuring out through all of the testimony kind of how wacky things were. And I think at one point, Pixie was unwilling to admit to my lawyer that it was her idea to record the videos. I think he asks a couple times and she says no. Her lawyers start screeching and objecting to asked and answered, objection, asked and answered. And then eventually my lawyer starts to read quotes to her saying, well, didn't you literally say this? Didn't you literally say this? Didn't Bono literally respond in the affirmative when you made the request? And then at one point, I believe the judge turns and asks her, he's like, hold on. He's like, was it your idea to record stuff? And then she's like, well, maybe. And then she's like, it's kind of like if you have a glass of water and imagine if somebody is standing there drinking a lot of water and they're like, wow, this is really good water. It's so good. And you're thirsty and you're standing there. And then you're like, well, can I have a glass of water? I would kind of say that they kind of like, that they offered the water even if you were the one who asked for it. It was just like, it's like, bro, are we being fucking serious right now? It is, this whole transcript is insanely fucking wacky, okay? It is a wacky fucking, the testimony, the court thing that day was fucking wild, okay? Jesus. Why is discovery going to last until December? I think that it just takes a while for court cases. Destiny, that's a Kiwi Farms argument. Blab argues you convince girls that recording sex is normal by sending them stuff. Oh, sure, yeah. They borrow a lot of their arguments from Kiwi Farms. Did I mention the paper shuffling yet? There's a lot of times. Where the judge, where opposing counsel on cross, is like asking me like some line of questioning, and it's just so stupid. And at some point, he just picks up his papers and starts going, because I can tell that he's like mind fucked himself on whatever line of questions that he had for me, because it's just so stupid. Wait, hold on. Hold on one second. Oh no! Ah! Sorry, hold on. I'm not reading from anything. I just had a recollection of a back and forth in court, but I'm not reading from anything. I was just looking at something totally unrelated. But it was really funny because I remember at some point the judge had asked her. He was like, so when did you first find out about these Google Drive links? Because they're trying to run with the Google Drive argument that they lifted from Kiwi Farms, basically. And at one point, I think the judge is asking her about, when did you first learn about like the Google Drive stuff? And she's like, well, I don't remember this at all, but I think that he sent me stuff relating of him and his wife at the time or whatever. And he was like, well, when did that happen? And she was like, I don't know, but it was before we ever met before. And I think the judge said something like, he's like, wait, so he sent you a video of him and his ex-wife hooking up? And she was like, I believe so, yeah. And then he's like, and that didn't give you pause to think for a moment that you guys were sharing? It was, oh shit, it was some funny shit. Oh my God. And then she tried to roll with the slut argument, where I think she started to say, well, no, Zip, do you remember this? And then she starts being like, well, I heard that they were in an open relationship, so I figured, that, maybe they just were more free or they didn't give a fuck about anything. Oh my God. Okay, sorry. Were they successful in sealing the transcript? No, it's temporarily sealed while the judge rules on it. So cringe. Oh my God, it was so cringe. Wow, Extra VB, thank you for the 5 gifted subs. Sorry, hold on. I'm reading something totally unrelated for 1 quick second. Doot. The Substack comment. All right, I'm done with that. One day. Okay. All right, stop. We wasted too much time on this today. Okay, so I've been looking into the exceptional case quote, and it's from the Doe v. Frank case from 1992. The ultimate test for permitting a plaintiff to proceed anonymously is whether the plaintiff has a substantial privacy right which outweighs the customary and constitutionally embedded presumption of openness in judicial proceedings. It is the exceptional case in which the plaintiff may proceed under a fictitious name. Oh, sure. Although this was in 92 before that one law was made, which literally has a carve-out for people to proceed under a pseudonym. Also, I don't know if this has anything to do with the witnesses, but... Okay. She's trying to bootstrap her anonymity onto the witnesses. I don't even know if they know what they're asking for. They're trying to, because they're trying to keep stuff from us. They're trying to file stuff anonymously. They're trying. I don't know if they. I honestly don't know if. I don't know.